Good evening and welcome to Global Television. You would have heard already, or if you have not heard, the Vybz Kartel versus the King case has come to its conclusion in the Privy Council. The conviction is quashed, but however, the Privy Council has remitted the question to the Jamaica Appeal Court as to whether there should be a retrial in the Vybz Kartel case. So we will bring it forward to you, and then we will no doubt return on the other side to look at some implications that could possibly comes out of this judgment, and what are the consequences of an automatic release for Vybz Kartel and his co-defendant pending the question to the Jamaican Appeal Court as whether there ought to be a retrial in the Vybz Kartel and others versus the King. Let us take a listen to the handing down of the judgment in the Privy Council in London this evening, and then we will come back on the other side.
And Andre St. John against the King.
On the 13th of March 2014, following a 64-day jury trial in the Home Circuit Court in Kingston, Jamaica, the appellants, Sean Campbell, Adidja Palmer, Kahira Jones, and Andre St. John, were convicted of the murder of Clive Lizard Williams, to whom I shall refer as the deceased. At trial, the prosecution case was that the deceased and another man, Lema Chow, had been given two unlicensed firearms belonging to Palmer for safekeeping. On the 16th of August 2011, Campbell summoned Chow and the deceased to Palmer's house after they had failed to comply with Palmer's deadline for returning the weapons. The prosecution alleged that they were met on arrival by Palmer, Jones, and St. John, and that Chow and the deceased were both attacked, after which Chow saw the deceased lying motionless on the ground with Jones bending over him. Chow escaped, but the deceased was never seen again. Police attended Palmer's house on the 22nd of August 2011. They noticed the house smelled of disinfectant. On the 25th of August, they cordoned off the perimeter wall, treating the premises as a crime scene. When they returned on the 27th of August, they found that the entire interior of the house had been destroyed by fire. On the 29th of August, police forensics reported a foul odor emanating from the living room. On a further visit on the 30th of September, it was discovered that the rear of the house had been demolished. Police dug at the premises but did not find a body. The police seized the mobile phones of Palmer and St. John. Text messages, voice notes, and a video from those phones were put in evidence at trial. The prosecution also relied on telecommunications data which the police had obtained from Digicel, a communications provider. The prosecution case was that the mobile phone evidence and telecommunications data, taken as a whole with Chow's evidence, proved the fact of the killing, the reason for the killing, the method of disposal of the deceased's body, and the identity of at least one of the killers, namely Palmer. The four appellants each denied murdering the deceased. At trial, the appellants objected to the telecommunications data being admitted as evidence. They argued that the data was inadmissible because it had been obtained in breach of the Interception of Communications Act and the fundamental right to the protection of privacy of communications guaranteed by the Charter of Fundamental Rights and Freedoms contained in the Jamaican Constitution. The judge admitted the evidence. He ruled that the data could be relied upon by the prosecution even if it had been obtained in breach of the Charter or the Interception of Communications Act. Over the course of a 64-day trial, there occurred a series of incidents involving the jury. The jury was reduced to 11 members after a juror was discharged almost 8 weeks into the trial. On the final day of the trial, it was brought to the judge's attention that a member of the jury, who will be referred to as Juror X, had attempted to bribe other members of the jury. The judge questioned the jury forewoman, who stated that Juror X had offered bribes to each of the other jurors to acquit the appellants. The judge asked counsel for the prosecution and the defense if the trial could continue. It would not have been possible only to discharge Juror X, because under the Jury Act, a trial for murder cannot continue with fewer than 11 jurors. The judge decided to proceed with his summing up and gave a direction to the jury, reminding them of their function. The jury retired to consider its verdict at 3:42 p.m. The jury returned at 6:08 p.m. and by a majority of 10 to 1 convicted all 4 appellants of the deceased's murder. A 5th defendant was unanimously acquitted. Juror X was immediately arrested and was later convicted of attempting to pervert the course of justice. There was no evidence to connect his activities with the appellants. The appellants appealed against their conviction to the Court of Appeal of Jamaica, which dismissed their appeals. The Court of Appeal granted permission to appeal to the Judicial Committee of the Privy Council on 3 grounds, which were, first, that the trial judge failed properly to inquire into allegations of juror misconduct. Secondly, that the trial judge departed from standard practice in inviting the jury to retire to consider their verdict so late in the day, putting undue pressure on them to reach a verdict. And thirdly, that the trial judge erred in admitting the telecommunications data because it had been obtained in breach of the Interception of Communications Act and the Charter. The Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed on the ground of juror misconduct, and that the case should be remitted to the Court of Appeal of Jamaica to decide whether to order a retrial of the appellants for the murder of Clive Williams. The board has considerable sympathy with the dilemma faced by the trial judge on the final day of a long and complex trial. Following the allegations of bribery, he had either to continue with the 11 remaining jurors or to discharge the jury. Despite this, the board considers that the approach taken by the judge was a material irregularity in the course of the trial, which makes it necessary to quash the convictions. This is for 3 reasons. First, the direction to the jury on the final day was inadequate to save the situation. The judge simply reminded the jury that they had sworn or affirmed that they would return verdicts in accordance with the evidence they had heard in court. The judge did not refer to the alleged bribery, of which, if the allegations were true, the jurors were already aware. Secondly, the trial continued with the allegedly corrupt juror serving as one of its 11 members. In the board's view, there should have been no question of allowing Juror X to continue to serve on the jury. Allowing Juror X to remain on the jury is fatal to the safety of the convictions which followed. It was an infringement of the appellant's fundamental right to a fair hearing under the Jamaican Constitution. Thirdly, the judge should have considered whether the remaining jurors might have become, consciously or unconsciously, prejudiced for or against one or more of the appellants as a result of Juror X's behavior. For example, there was a danger that the attempted bribe could have made the other jurors overcompensate, consciously or unconsciously, if they assumed that the offer must have come from one of the appellants and that therefore they must be guilty. The judge took no account of this risk. The board is very mindful of the serious consequences which may flow from having to discharge a jury shortly before the end of a long and complex criminal trial. It is also very conscious of the danger of deliberate attempts to derail criminal trials by engineering situations in which it is necessary to discharge the jury. In England and Wales, there is legislation which allows a judge in certain situations to discharge a jury because of jury tampering and to continue the trial by judge alone. There is no such legislation in Jamaica. It follows that there will be occasions where, as in this case, a court will have no alternative but to discharge a jury and end the trial in order to protect the integrity of the system of trial by jury. In view of its conclusion on the issue of juror misconduct, the board holds that it is not necessary to express a concluded view on the other two grounds of appeal. For these reasons, the appellant's appeals should be allowed. The court is now adjourned.
There you have heard the Privy Council handing down their decision, quashing the conviction. However, there's a question that ought to be remitted to the Jamaican Appeal Court as to whether a retrial should be ordered in the killing of flied lizard. But you heard in this handing down of the judgment that the conviction was unsafe because of the juror misconduct. And the direction that was given by the judge was inadequate, as the justices are saying. And by the way, it's a unanimous verdict, meaning all the 5 justices hearing the case agreed on the judgment that was delivered today. But the inadequate direction wouldn't have saved the day, as the judge said. So we see 2 of the major things coming out of this: the infringement of fundamental rights, the infringement of your constitutional right. That is one of the things that come out of it. The unsafeness of the conviction, given the tampering of the evidence, because that's where the breach of fundamental rights came from, because of the way they went about securing evidence from his mobile phone in order to rely on evidence. So that's where the infringement on fundamental rights is coming from. And with the unsafe conviction, that comes also from the juror misconduct, which, though late into the trial, the judge have to still observe the procedures of justice and the fairness of justice. And it would have been expensive, but what they could have done is collapse that entire trial, set a new trial date, choose a new panel of jurors, and restart the trial. What the judge and the DPP did was chose to turn a blind eye to what they should have focused on. And this is where we are today, where the question is going back to them to answer. Do you have enough evidence to secure a safe conviction in public interest? Do you have, should there be a retrial as a matter of public interest? Or should there be a trial as a matter of public interest? Or do they have enough evidence? Sorry. Do they have enough evidence that can secure a safe conviction? Now, if there's flagrant breaches ruling out of the Supreme Court of the Privy Council ruling in context to the gathering of evidence in convention of his rights, even though they are saying the Interception Act allowed them to, but that was a violation the way they went about it. They wouldn't be able to rely on that evidence in a new trial. And that was a strong piece of evidence for them. So it would be interesting to wait and see if Paula Llewellyn will submit such question to the Jamaica Court of Appeal. But what are the consequences coming out of this ruling for our justice system? Because this is really a slap in the face. There's going to be debate around juror tampering, the integrity of juror trials, the integrity of our justice system, and whether it can protect us and serve justice to us. The question can also be asked as to how much more of our young men are in our prison system who did not receive a fair trial, or who the evidence was botched or shoddy against them, but because they are from a poor background or downtown Bacawal, Jamaica, then they did not receive a fair trial. What debate does this open up for our justice system as a whole? Will the nation be calling for Paula Llewellyn to go? Can Paula Llewellyn continue to lead our Department of Prosecution? What is this for the Jamaican justice system? These and other questions will become widely discussed over the next week or so. And I'm sure there's going to be a lot of debate as to what is the consequences coming out of this ruling. There is a technicality to the automatic release of Kartel and his co-accused, given the question of the conviction, that I'm not able to explain to you right now. That hopefully will be explained later. But because a question is to go back to the appeal court, I cannot explain the technicality of that to you at the moment if it affects his automatic release.
Sorry, I'm having trouble connecting to the internet. It looks like there's an issue with the router and echo device, so try restarting them. Unplug both of them, then plug
Something tapped the nails.
Wait 30 seconds.
Me now ask you
Once the router is back on and connected to the
anything. I
internet,
saw the same
open
thing,
the
yeah.
echo device.
The foreign same thing you walk and make nice. Sorry about that, people. But for the remittal of the trial, we will have to wait to see if that have any technical bars to his automatic release. But Jamaica has had its own Johnny Cochran in an Isaac Buchanan. Isaac Buchanan had taken this fight for justice forward, and this ruling today is not just about Vybz Kartel and his co-defendants, but this is about justice being observed and held, and the integrity of our justice system. And if we're going to continue to use the system of juror, then we must have confidence in our system of juror trial, as well as confidence in those in our judicial service, from the point of investigation, prosecution, and conviction. We must be able to have confidence that all the processes are followed, and that when we achieve justice through safe route and not bending the rules of justice in order to achieve justice. And this is why we see today Vybz Kartel and his co-offendant conviction has been quashed by the highest judicial bench in the Commonwealth, because a corrupt justice system, a corrupt DPP did not do it right. Paula Llewellyn must resign and therefore not waste any more of taxpayers' money. And if there is an application going to the appeal court, Paula Llewellyn, who has botched and messed up the situation, should not be able to take this case forward. Thank you very much. This was the judgment summary of Vybz Kartel and his co-defendant versus the King. Thank you very much.